Do y'all want a record for this?
Yes, Your Honor.
Okay. All righty, let's go on the record on cause number DC 2011128, Wellington Interest Inc. versus Genevieve Joquets. Counsel, make your appearances.
Good morning, Your Honor. Ken Harder here for the plaintiff, Wellington Interest Inc.
Good morning, Your Honor. Andy Laddick here for the defendant, Genevieve Joquets.
Let's proceed.
Thank you, Your Honor. This is a trespass to try title case. The long and the short of it is that the defendant owned a condominium. She evidently fell behind on her dues. The condominium association placed a lien to secure its dues. When the dues remained unpaid, they foreclosed and my client bought the property at sale. The motion for summary judgment includes certified copies of the deed records showing that the defendant originally acquired the property in, I believe, 2005. It shows that the association placed a lien on the property on December 17th of 2019. And that my client purchased the property at an assessment lien sale with its deed recorded on March 6th of 2020. After we initially convened about a month ago, I also got a certified copy of the condominium declaration, which was also on file and was filed 3 weeks ago. And that's just the declaration showing the authority of the association to place a lien for assessments on property in order to secure
So,
a base.
so Mr. Harder, the defendant is claiming that she had no personal notice of the alleged foreclosure or an opportunity to cure the alleged lien filed against me by the homeowners association. And I know we talked about that condominium association foreclosures are not covered by Rule 736, but do you have an opportunity to cure in that situation?
Your Honor, the obligation of the HOA was to serve the defendant by certified mail. And there's nothing that indicates that they did not do what they were obligated to do. If the defendant never picked up her mail, then that's an omission that's on her and is not of any legal significance. Now, in her response to the motion, which has a very brief affidavit on her part, what she says is that not every item in our motion is true. She doesn't really say what items she says are not true. She says that she says, I have personal knowledge of the suit for possession, which is this case right here. She says she was served by the process server in this case, but she doesn't really say that the foreclosure was somehow illegal or unlawful or not properly done.
What she says is, regardless of the plaintiff's deed, I had no personal notice of the alleged foreclosure. Let me go ahead and share screen this just so we're kind of all on the same page. Because you see the last sentence there. Regardless of the plaintiff's deed, I had no personal notice of the alleged foreclosure or opportunity to cure the alleged lien filed against me by the homeowner association. So I'd ask you the question, Mr. Harder, I just want to make sure.
Right.
I'm not as familiar with these condominium association foreclosures as I am with the property owner foreclosures. So do they have, I know with homeowners association liens, you have an opportunity to cure. Is there an opportunity to cure for condominium association liens as well or not?
Well, there's not an opportunity to cure per se, other than a notice of lien has got to be sent to the homeowner, and a notice of sale has got to be sent to the homeowner, and the opportunity that the homeowner has to cure is before the conducting of a foreclosure is to go ahead and to, at that point, pay the lien. Also, there's a redemption period in
Okay, that's what I was thinking of, the
Okay.
redemption period.
Right, there's a redemption period, and the redemption period is 90 days from the date of the sale. And the homeowner has a right to redeem within the 90 days. And there's nothing in her affidavit that indicates that she tendered a redemption amount, much less made a redemption demand or any kind of redemption inquiry. And I would tell the court that I just had a case out of the Fort Worth Court of Appeals that had to do with redemption. And that case was a little different because in that case, the homeowner was trying to make the argument that the COVID orders of the Supreme Court extended the redemption period beyond 90 days, which the Court of Appeals rejected that argument. And then it also went on to discuss redemption and the requirement that a homeowner substantially comply with the redemption process. And in this case, there's nothing that indicates that she did anything to try to redeem. So yes, there's a right to redeem, but no, she did not redeem in this case. And I don't think redemption is an issue. It's not been raised by her in any of the pleadings, whether as a part of an answer or part of a counterclaim. And interestingly, there's not any kind of a claim being made in court that there was any deficiency in the foreclosure process. There's no counterclaim for declaratory relief or anything like that. There's not a third-party claim bringing in the HOA. Essentially, what she's saying in her affidavit is, I don't know anything. It's kind of like the Sergeant Schultz defense, I guess. And I don't think that that's anywhere near enough to get to the point where we're raising a question of fact as to whether or not my client owns the property.
Response.
Well, Your Honor, the redemption is a little bit of a red herring on his part, bringing that up now, because the redemption, she did not even know of the foreclosure until she was given a copy of the eviction lawsuit that they filed after the 90 days had run. So she had no notice of it. And that by and of itself, which she also says in her petition with an affidavit, she had no notice of it. In her petition and her affirmative defense, that she had no notice of this foreclosure. Secondly, plaintiff cherry picks the deed records, and what our expert had pulled was a chain of title. And in the chain of title, there are other documents besides the one that he filed exactly 21 days before this hearing. However, the second supplemental response filed by the plaintiff was less than 21 days from today's date. And that included information from someone saying that he was the trustee and guardian of the records for this HOA. The issue is here also, there is another case pending. And again, I'm not going to say that this attorney, you're being cherry picked, but also there is another lawsuit in the county court at law. Now, the county court at law is the appeal from a JP eviction that I mentioned earlier. They won the summary judgment in the JP court, regardless of this suit pending in the district court. So we, of course, appealed it to the county court. Well, believe it or not, this is actually set for trial tomorrow. And we've also asked for tendered a motion for it to be reset and not heard pending what's going on in your court, Your Honor, because there are enough facts here, enough documents that we believe, and my client believes, and the expert that we had believed that this, based on what was filed and what was disclosed by the plaintiff, they do not have a good foreclosure, nor did they give her notice of the foreclosure. And we are just now seeing documents that he purportedly filed only, well, as of today, 20 days ago, and wasn't disclosed to us in any discovery in support of his motion for summary judgment, which I would like to accept to, because, well, as the court knows from our last hearing that we had, plaintiff had not seen the response. And it wasn't, he even mentions that we did not file it, but we had filed it. He just did not open it. So just because he didn't open it is why we reset his motion for summary judgment today. Now, in the meantime, coincidentally and horribly for my client, the expert witness, Mr. Joe Gordon, suddenly had a heart attack and passed away. So I have been extremely pushed to find another expert that can find us or go through this chain of title and become our expert. So again, there are enough facts here that we asked for a jury trial because there are facts that will show this. Also, isn't it strange that he has not laid out all the documents for the homeowner association? The homeowner association actually has provisions in it for fines only, no foreclosures. And isn't it interesting that that wasn't brought up of why there was no notice of any fines either that my client received or should have received. So we've have a lot of issues here for fines, and there was a notice of an assessment lien filed, but there's also a release of an assessment lien filed. And I do not have a certified copy of it, but had it been included in a title, a true title search, which I think the plaintiff should have shown that he has good title, not just by deed, but then how he got it, he didn't include the release of the assessment lien that was filed. And again, there are a lot of fact issues here we want to see go in front of a jury, but also that we have the proper time to pull up and bring in the homeowner association if we need to. We'll prove up that he does not have good title. We will prove up that he does not have good title. And the way that I was always taught to show on a quiet title action is the burden doesn't shift to us to prove we don't have good title. He's got to show that he's got good title, and he has not shown that by a chain of title. He has purposefully cherry-picked documents to show the court of his alleged title. And I just think the court is not getting the whole information here. And we would either, one, ask the court to find in our favor for the summary judgment, or postpone it long enough for us to find another expert witness, to replace Mr. Gordon, and continue our discovery with the plaintiff in this matter. It has not been on file that long, and as you know, because of COVID, the restrictions just being released. Again, we have another case pending, exact parties pending in the county court, and the county court was shocked that this was going on in this case. I did call when I was in Florida last week with my son and my daughter-in-law, and just to see if there was any way I could just ask. I just announced that we were not ready because of this case pending here.
Judge, if I may, real briefly, I'm not handling the case in the county court of law. I'm aware of it. That's just a JP appeal from an eviction, which is different than a TTL, and the two cases have really no effect on each other. If that case goes forward tomorrow and the court finds that Wellington is entitled to immediate right of possession, that's different than the question that's before this court right now. The question of the expert, Your Honor, I filed an objection to consideration of that affidavit. You can't have expert testimony on a question of law. And Mr. Leidick has not provided any authority that says anything to the contrary, and I certainly provided authority to the court that says exactly that. And I take a little bit of umbrage at Mr. Leidick saying that I'm cherry picking documents that I put before the court. He certainly has every opportunity, has had every opportunity to bring before the court other documents in the property records of Dallas County to somehow show that there's, not clear title held by my client in this property. You have before you the deed that shows that the defendant in this case had acquired title. You've got the HOA declaration, which gives the HOA the authority to place a lien and to foreclose the lien. You've got the notice of lien, you've got the trustee's deed, and there's not a shred of evidence put before the court that somehow would impeach the efficacy of title in my client or the efficacy of the process that had taken place before we got to the point where the sale actually occurred and title went into my client. What we've got is a very brief affidavit from the defendant saying, basically, I don't know anything about anything, and so therefore, what the plaintiff is saying.
I guess my question to you, Mr. Harder, is, I mean, he's filed it. His client says they don't have notice. The expert says there's not a proper chain of title. What else could you do in this situation other than what he's done?
Well, to begin with, an expert report saying that there's not a chain of title is not evidence. I think it's incumbent upon Mr. Leidick to explain to the court, based upon statute and case authority, why the documents proffered to the court are somehow inadequate to sustain the position that we're taking. In terms of the affidavit from Ms. Dockets, there's nothing in there that contradicts any fact upon which the court can grant us relief. We have a copy of the notice of lien. We've got the trustee's sale deed that goes to the question of title, and there are no pleadings before the court that somehow contradict the veracity or efficacy or legality or propriety of the foreclosure sale that took place. And the fact that she says that she didn't have notice of the sale is not evidence that there was not notice of the sale given to her. And again, she's not raising that in terms of any kind of a claim or defense that says that she remains entitled, notwithstanding the trustee's deed. And again, this issue of a quote unquote expert is talk about a red herring. I say that's a red marlin, because you can't have an expert tell the court what the law is. That's up for the court to decide. And again, I can't emphasize enough that I'm sort of astonished that we're hearing about so-called cherry picking of the deed records, when if there's something on the property records that Mr. Leidick thinks is helpful to his case, he certainly has had every opportunity to go get those copies and put them before the court, and I haven't seen it.
Mr. Leidick?
Oh, well, Your Honor, in this situation, Mr. Gordon was the expert witness. He was the one that had the chain of title run. He was the one that went over the documents. And yes, we were going to supplement our answer to his rebuttal to his motion, or our rebuttal to his motion for summary judgment. We were going to do that. Mr. Gordon passed away on the same day that we had the first hearing, roughly 30 days ago. Mr. Gordon, we did not find out after phone call, didn't find out that he had passed away until a week after. And then, yes, we've had opportunities to go, but as you are well aware, I asked for this hearing. I think Mr. Harder wanted to have it last week. I asked for it to be this week because I was going to had plans to be in Florida all week. We literally got in at 11 o'clock last night for this hearing today. I see that Mr. Harding actually filed his rebuttal to my client having no notice, actually less than 21 days before this hearing. He filed it on the, I believe, on the 6th.
All right, you've said that already.
And I'm just saying that this is a situation where these facts should make enough that we should be able to go forward in this case and not have a summary judgment. Just for the fact of the documents that have been recorded, you know, I am amiss that
Mr. Leidick, I'm going to go ahead and deny the summary judgment. So go ahead and get me an order on this, and
Thank you, Your
we'll
Honor.
go from there. All right, anything else, guys?
Nothing further from me.
When are you all set for trial? I think August 10th.
Yes, Your Honor.
Be aware there's a chance we might go. We're starting up jury trials June and July. We only get one day a month to do jury trials in June and July. I don't know what will happen in August. There's also a possibility that we would, if we only get 1 or 2 dates, that we're able to pick a jury, the 68th is able to pick a jury that month. We may have to move the date, but as of right now, I'd suggest just keeping it that date and kind of seeing what happens. But be aware that there is a possibility we may go to trial that day.
And Your Honor, what is the court's rule about adding a third party now that we have Mr. Harder provided us with this information that this is an active person? Do we need to make a motion to add a third party at this time?
You just need to follow the rules.
Yes, Your Honor. Thank
Your
you.
Honor, has the jury fee been paid in this?
Yes.
It's on the jury docket, so it should have been. I can
Okay,
check. If
all
you
right.
want. But let me double check. If you think it maybe hasn't been paid, I'll verify that real quick.
I don't know one way or another. If Mr. Leidick says it's been paid, I'm sure it's been paid.
Let me see. It is on the jury docket, and a jury fee was paid last September 28th.
Okay.
Okay, guys?
Okay.
Okay, thank you, Your Honor.
All right, make sure, Mr. Leidick, when you submit the order, you email my court coordinator, also e-file it, and on the date, and when you're submitting the order, put today's date. So on April 26, 2021, the court considered the motion and it was denied. Don't just put on this date so that I can tie it back to this particular date, okay?
Yes, sir. Thank you very much, Your Honor.
Thank you. Bye-bye.
Okay, thank you, Your Honor.